All right, thank you all for joining the second webinar in the 2018 MSHA Defense webinar series. Today we'll be discussing where does MSHA jurisdiction begin and end. I will be your host for today. My name is Nick Scala. I am the chair of the MSHA practice group here at Con Maciel Carey. Our group represents independent contractors and operators all around the country in MSHA contest work, investigation management, as well as jurisdictional challenges, whether you are seeking to have a mine facility previously under the Mine Safety and Health Administration removed and put under OSHA, or a facility that maybe has been under OSHA and is more appropriately inspected by MSHA. We've also helped in those situations. But with that, we will get going. I do want to give a bit of a disclaimer, but when we are talking about jurisdiction, it is very much rooted in the definitions included in the Mine Act, as well as the Memorandum of Understanding between MSHA and OSHA. So there will be quite a bit going back and forth and reviewing the definitions that are included in that, in those documents, in the beginning slides. And that will take us through the first several points in our agenda today: what is covered under the Mine Act, reviewing that interagency agreement and what is specifically enumerated and divided between the different agencies. We'll also look at an element of jurisdiction that is beyond just looking at is this facility or is this location covered by MSHA, and that is looking at what miners are going to be covered by MSHA, especially for the purposes of independent contractors. This is something that as operators and independent contractors, all parties need to be aware of so that we can avoid citations and 104G orders for having untrained miners on site. And then we will review some recent commission decisions from both the Federal Mine Safety and Health Review Commission and the Occupational Safety and Health Review Commission, as well as the Federal Circuit cases which followed them up, to outline a couple of distinctions with the jurisdictional questions and how those courts have really shaped some new interpretations even in the last couple of years. So let's start off big and broad. Let's look at the Mine Act of 1977, and this is the statute that created MSHA. Previously, you did not have the Mine Safety and Health Administration. That changed in 1977, and they specifically outline in the beginning portions of the Mine Act what mines will be subject to their jurisdiction. And it very clearly says each coal or other mine, the products of which enter commerce and or the operations affect commerce, and each operator of such mine and every miner shall be subject to the provisions of this act. So, obviously that is a broad enough and gray enough definition that questions arise about what is going to constitute a coal or other mine. Also, though, this language should be familiar to anyone who's gone through the contest process, as if we are going to go through that and we receive a petition for the assessment of penalties from MSHA, which initiates our formal contest process, the first elements of that document outline that this is a coal or other mine, that the products affect interstate commerce, and that you are the operator of such mine. And I bring that up because if we want to contest jurisdiction, MSHA's jurisdiction in particular, over a particular facility or a particular piece of equipment, we need to do that. We need to be thinking about doing that as early as we become aware of the confusion or MSHA's decision to assert jurisdiction over that piece of equipment. But also, if we have received a citation and we're contesting that citation, when we respond to the petition for assessment, we want to make sure that we deny that this is a coal or other mine, that its products are affecting commerce, if that may be the case, and that we are the operator of the mine. So those are some elements that are included at the beginning of each formal contest process, that if we are going to contest jurisdiction after we've been assessed a penalty and a citation and a penalty, we want to make sure that we're denying those elements very early. So, as with most things, MSHA, back when it was initiated in the 70s, we see that it is focused on coal or other mines. And, that is a very broad definition, and we'll see that definition throughout, looking at the Mine Act itself. But in particular, MSHA did give some guidance as we got started when this process began about what is a coal or other mine. And we can see from that it's an area of land from which minerals are extracted. And there's a lot of different provisions down there, but it also includes private ways or roads appurtenant to such area, and or the structures and workings that are used in, to be used in, or resulting from the work of extracting materials or minerals from the natural deposits. And then also down at the bottom, we see that MSHA installs here a word, the milling of such minerals. And we're going to be spending a significant amount of time today discussing what constitutes milling. And that will be especially important several slides from now when we start looking at the interagency agreement with MSHA and OSHA, because really looking at milling is going to be a central focus when we're trying to determine what these kind of gray area activities where we're dancing the line between mining and manufacturing. Milling is going to become an essential part of that question. So some of this should be unsurprising. It is going to be the land that the minerals are extracted from, private roads and ways and roads appurtenant to such area, meaning our haul roads and the entries points, as well as the structures and equipment that are used in that process. So really, it says a lot of words to convey a fact that we all know. MSHA is a strict liability statute the Mine Act is a strict liability statute, which gives MSHA jurisdiction over our land, our equipment, and our facilities and roadways used in the mining process. So, the definition even goes on to determine what is going to be constituted as milling, and it says that when making this determination, the secretary, meaning the Secretary of Labor, shall give due consideration to the convenience of administration, meaning which is it more convenient for the agencies, or which of the agencies is it more convenient to inspect the area, OSHA or MSHA, resulting from the delegation to one assistant secretary of all authority to inspect the health and safety of the area. So that's really saying, and this is still an analysis that we have to argue when we are going through a jurisdictional challenge today, is there going to be a significant burden on OSHA or MSHA if we switch jurisdiction to either party? And that decision, essentially, it comes down at the final part to the Secretary of Labor. They have the ability to make this decision. Now, that is many facets down the road. You are typically going to go through the field office and most likely your district level as a mine operator. It will then go to the national office where final decisions are made regarding these topics. If the district doesn't have the authority to make that decision itself, there'll also have to be some communication between MSHA and OSHA to determine that, for the example that we are contesting MSHA's jurisdiction over a facility, that OSHA is willing to take that on. So, the Mine Act, it really outlines kind of that broad level. Everything at a mine is going to be under our jurisdiction. If there's a question about milling, the Secretary of Labor gets to make that ultimate determination. Now, the question of milling, I told you we're going to talk about in great deal looking at this interagency agreement. And the Mine Act, or shortly after the Mine Act was written in 1979, MSHA and OSHA signed what was called a Memorandum of Understanding, or an interagency agreement. And the purpose of this was to set forth the beginnings of a jurisdictional divide between the two agencies. And this was not only for their own purposes, but also it was to serve as guidance to employers and employees in determining which statute applies, the Occupational Safety and Health Act or the Mine Act. And when really looking at this, it outlines not only how the jurisdiction is going to be divided on specific locations, but also how you go through contesting it. And as I said, that will be involving your district manager and your district personnel from the mining side. It will be area directors on the OSHA side. It will, outline specific elements of the mining process and what the definition of milling really is. And to look at that, we'll just particularly look at milling, and we're going to have to do so for several slides because it really is a key element in determining what areas are going to be under MSHA jurisdiction and which areas are going to be under OSHA jurisdiction. And most frequently, when we are contesting jurisdiction, it's going to come down to what is happening in terms of the milling of material. And so the Interagency Agreement refers back to a section of the Mine Act, and that is Section 3H1. And it says under that section, the scope of the term milling may be expanded to apply to production or product manufacturing processes where they are related technologically, geographically to milling. Or it may be narrowed to the specific list processes listed in Appendix A, where they are, or outside of those processes where they're unrelated technologically or geographically to mineral milling. So what does this mean? This means that milling, as we said before, is really going to be our dividing line between mining and manufacturing. And whether or not a process fits in there for the purposes of a mine operator, a production operator, and what's taking place, Appendix A lists out a number of specific industries that will fall under OSHA and MSHA. And if we are going to be contesting this, we're going to be looking at how related is this process to what is listed in Appendix A, and in terms of the geographic or technological relation to the mining and milling process. So, the most likely candidate for where this conclusion is going to come, and we'll talk about it a bit more with some specific cases later, is where we are done with the mining process, but on the same site, we begin to do other activities, whether that is washing or drying or mixing. And those are really going to be some of the areas where we come into this question of, are we under MSHA jurisdiction or are we under OSHA jurisdiction? So specifically in here, we define milling as the art of treating the crude crust of the earth to produce primary consumer derivatives. And the essential operation is a separation of one or more valuable desired constituents of the crude from an undesired contaminants. Okay, so what does that mean? It means we're separating out what we have mined from the good material that we want to sell. And that process, the milling, is going to be the separation of that. So it's going to be crushing, sizing. It is going to be whether or not we are looking at washing, drying in some circumstances. Are we going to be doing some sort of manipulation of the material? That is what is going to be considered milling for the purposes of MSHA jurisdiction. And if milling is occurring, it is under MSHA jurisdiction. That is typically where the argument lies. So it is in the Interagency Agreement, it is established that milling operations are going to fall under the purview of MSHA. So if we are arguing that something is not under the purview of MSHA, it means that no milling takes place in that facility or at that step in the process. And, more so, even clearer than this milling, in the Interagency Agreement, they outline specific operations that are going to be subject to MSHA and OSHA. For example, they very clearly say that MSHA is going to have jurisdiction, and this is in Appendix A, under mining operations, underground mining, open pit mining, and quarrying. Well, that is pretty clear. That's going to tell us where we're at. But then also you're going to have anything that constitutes milling, as well as cement facilities and other types of operations. Also what they do, though, is they outline what facilities are not going to be on the MSHA jurisdiction and that OSHA is going to have the regulatory authority under. And that's going to be things like brick and clay plants. Even though the mine will be under MSHA's jurisdiction, the plant will not. Similarly, one that comes up very frequently is concrete ready mix or batch plants and asphalt plants. While these are very often on mine sites, they are not subject to MSHA's jurisdiction. The mine inspectors cannot go up there and issue citations. Now, obviously, if they see an imminent danger occurring or someone doing something inherently unsafe, that's a different situation. But on a normal basis and in the course of a normal inspection, the Mine Safety and Health Administration inspectors should not be touching asphalt plants that are on mine property or ready-mix plants that are on mine property. There's also, the question of where does the equipment, what about equipment used in this area? Because oftentimes there's not a lot of separation between our mine site and these OSHA facilities, if they're a ready-mix or an asphalt. And oftentimes we also see people who are using equipment between the two facilities. And so the question arises, what happens if, I have a front loader that is operating on both properties or servicing both the processing plant, which is separating material, as well as a asphalt plant on site. What I'd say in that case is if it is touching the mine site and participating in the mining process, MSHA likely is going to have jurisdiction over that piece of equipment, even if it works on both facilities. But that does not blur the line between them having jurisdiction over the actual asphalt plant. There's a question, so I'll read that back quickly, but it says, how about a customer that leases land from a mine, that buys material from the mine, and subsequently blends the material with other non-mined materials and sells the product to their customer? So we are dealing with a facility, it sounds like, that is on a mine site, but we are not specifically extracting the material, but we are blending it with material from other non-mine minerals. Okay, so in this situation, it's going to be looking at what are we doing to blend this material, and how related to the mining or the manufacturing process is that. So if we are blending it and also sizing it and crushing it, or washing or drying it, that's going to be milling and would most likely fall under the jurisdiction of MSHA. You don't specifically have to mine the material to be under their jurisdiction, and that's actually a case we'll talk about a bit later, where similarly a company buys materials and they're a stockyard, but then they size the material and separate it into different sizes when it gets there, so that brought them under MSHA's jurisdiction. This sounds like it could be a similar situation, but it's a blurred line, so to speak, because if you are using only final product from the mine and you are not engaging in any of the milling, meaning you're not crushing and grinding, you're just mixing it together with another material for the purpose of increasing its market to customers, it could also fall under the jurisdiction of OSHA. So I'm sorry I can't give you a very concrete answer on that, because these, as one would expect, are very, very fact dependent. And when we talk about the cases here in a few minutes, there's going to be several that relate back to this question. So if there is a follow-up question, please feel free to ask it again. But I think the analysis has to look at more detail in your question as to where is the material coming from and what's being done with it once it gets to your customer facility or the lease side of the mine site. So, with that, we continue to look at some areas where there is a jurisdictional divide between MSHA and OSHA. And another one that we probably have heard about in the past is borrow pits. And the question is, what is exactly a borrow pit, and how do we qualify as a borrow pit if we don't want to be under MSHA's jurisdiction? I would say that the area, if you are going to satisfy as a borrow pit, this is the definition that's included in the Interagency Agreement. And I specifically bolded a section in the middle, which I think when the analysis comes into play, when we're looking at a site to see if it is a borrow pit, these are what the judges most frequently look at, and that is how often does extraction occur from the site, what is the intended use of the material, and was there any milling done? So milling goes back to the questions of what we were just talking about. Are we sizing it? Are we crushing it or grinding it? Or are we intending to have it manipulated in some way, shape, or form? Or are we just using it because we need fill material? So, that is a question. Typically when we're dealing with a borrow pit, it's a small operation, it's relatively unsophisticated, and it's being used only for material in its raw form. Now, with that being said, these are weighted factors. So it's not just, is there anything being done, or does it only occur as a one-time basis? There is give and take between them. One case that's going up through litigation right now, and it's actually challenging a much more broad issue, but at its heart, it was a jurisdiction issue about whether or not a quarry, and I say that because the judge found it was a mine, that property was being used in the process of a construction project, and the company was extracting material to be used in road construction. And MSHA claimed that it was a mine site because the company was operating it 6 days a week for a year, so they argued not intermittent or as need occurs. And they were arguing that there was sizing taking place in the form that the company had dimensions of materials that they were needing to meet spec of this road construction job, and they were using a hoe ram on an excavator to size material to that specific, or those specifications. Also in that case, MSHA alleges that the company was not only using it for this purpose, but also selling it, which brought it into interstate commerce. The company was arguing that it wasn't a one-time basis for the life of this construction project, and that was how it was satisfying the borrow pit argument in that, and also that sizing by use of a hoe ram did not constitute milling. So in that case, the judge found that the mine was, or the facility was a mine because of the sheer amount that they were working, as well as the use of drilling and blasting in the process to size and break material into specific quantities or specific size and weights. So that is an area that we need to evaluate. Now, I know down in the southeast United States, I've worked with several sand pits, and in these situations, they are operating facilities that are nothing more than a excavator and maybe a bulldozer to remove overburden, and they are loading the material directly into trucks, which it is then taken off site for its use by end users. And that may be companies that are still under MSHA jurisdiction, like cement companies, or it could be use in other non-MSHA capacities, such as landscape. And in that situation, there have been companies that we've successfully removed those sites from MSHA's jurisdiction, meaning that they were previously being regulated by MSHA, and we've got MSHA to give up that jurisdiction at the time, for the time being, because they found that there is no milling taking place. There is no mining taking place. You're just removing material for its bulk qualities and you're not doing any kind of milling that would constitute the mining process, even though those operations are, selling the material into commerce, and you're also using them or operating them on a consistent basis. It's not a one-time only or an intermittent basis. So again, I say that to bring forth that this is really a graduating factor, and you need to weigh, again, all the facts and how things are going to look when you put it before MSHA. Similarly, down in the south central portion of the country, we've had some success in getting pug mills out of MSHA's jurisdiction. And MSHA wanted to say that you were engaged in the milling process to begin with because you're injecting water into the material. And we were able to get MSHA to relinquish control over the pug mills as long as they were being operated independent of a crushing facility or another plant that was working with milling. And with that, we'll talk about portable crushing plants and when they may or may not be under MSHA jurisdiction. But, in many cases, these portable crushing plants, you have to have a mine ID for it, and it travels with that if you are going to go to a facility and extract material and crush it for the purpose of selling it into commerce as one would with a mine. The question sometimes arises if you are going to be using that for non-mining purposes, such as crushing recycled products. And in that case, MSHA would not have jurisdiction. You would be under OSHA's jurisdiction in that operational capacity, even if you are going to be on a mine. So again, it really determines what you are doing as much as it is where you're at. So those portable plants, again, may or may not be under MSHA's jurisdiction. Pug mills may or may not. Those are very fact-dependent operations where the equipment, depending on where it is and what it's doing or what other equipment it's working with for pug mills, you may or may not be under MSHA's jurisdiction. Another element that I think is important to talk about when we're talking about jurisdiction is MSHA's jurisdiction over miners. So we know that MSHA not only covers all these coal and other mines, but it also covers miners, meaning anyone who's working on that. They further go to define what is a miner under both Part 46 and Part 48, and we'll look at both of those, which are their training plans. And under Part 46, a miner is considered any person, including an operator or supervisor, who works at a mine who is engaged in mining operations. It includes independent contractors and employees of independent contractors. It also includes any construction worker who is exposed to the hazards of mining. And the hazards of mining and mining operations, these definitions are, shall we say, never-ending. We could go through 200 slides of definitions on these, but they specifically outline some of the activities in mining operations to be the haulage within a mine, so excluding customer truck drivers, participating in the mining process, meaning extraction or processing. The hazards of mining can be whether you are involved in working by high walls or just near the traffic of haulage equipment. So it can be that broad. Also, what we see, though, is in Part 46, it specifically outlines in that section, which begins with the number 2, what is not included as a miner. So the scientific workers, delivery workers, customers, including over-the-road truck drivers, vendors, and visitors, are not considered miners, and therefore they are not subject to the training requirements under Part 46. It also does not include maintenance or service workers who do not work at a mine site for frequent or extended periods of time. And that is a statement that we probably heard before if we have contractors come on site or if we've had MSHA conduct an inspection of contractors on our site. But frequent or extended periods of times, we'll look at that a bit more. But when we are thinking about who needs comprehensive new miner training under Part 46, this is what we need to look at. And if we are an independent contractor, we need to evaluate whether or not we satisfy this definition. And also as an operator, we need to make sure that if we are bringing on an independent contractor, if they do satisfy this definition, that they are provided with, or they provide training to those employees that will be on site. Not that you have to provide it, but you should ensure that it is completed. I will note that even though the individuals listed in that bottom section of which are not minors, those individuals still require site-specific training, site-specific hazard awareness training. And we want to always remember that everyone that comes on site needs to get site-specific hazard awareness training. Just because they don't need comprehensive mining training, meaning that 24 hours for Part 46, doesn't mean they don't get site-specific. So that is just a brief disclaimer with that. If we're looking at Part 48, the definition is a bit different, but it specifically includes people who are engaged in the extraction or production process, or work in an underground mine, or work in construction of an underground mine, or is regularly exposed to mine hazards, or a maintenance or service worker who works at the mine for frequent or extended periods. So again, we see that question come up, frequent or extended periods, and I see there's a question about the definition of frequent, and I think we're probably going to answer that in the next couple slides, and so we can still talk about that if I don't answer your question. But the question is the frequent phrase a gotcha standard by MSHA? And there is some guidance on it that we'll discuss, but nonetheless, if you have people on your property engaging in any of these activities, they are going to have to be comprehensively trained. If you're outside of this activities, then the question needs to be asked, do these individuals need comprehensive training? Does MSHA have the ability to cite me as a company or cite me for training purposes? And that's an important element as well. Even though our people, if we're a contractor or a contractor on our site, may not be required to comply with MSHA's training requirements because they are not minors, or their employees are not minors under the Act, they can still receive citations. If you are working on a mine site as a contractor, if you are doing something out of compliance that falls within the definition of mining operations or the construction of mining in mine operations, you can be issued a citation regardless of whether you're on site for frequent or extended periods of time. That is a question that comes down to training requirements, not jurisdiction. If you are on a mine site engaged in those activities, MSHA has jurisdiction over you. As we talked about earlier, it is a strict liability statute, the Mine Act is, and MSHA has the ability to cite any operator, and that includes in that definition of operator, production operator, as well as independent contractors. So, as we talked about the frequent and extended question, there is guidance on that. MSHA has on its website available a program policy manual, and this is guidance on their interpretation of different standards. And in that, in both Part 46 and Part 48, they touch on what is frequent or extended exposure. Now, both Part 46 and Part 48 say that extended exposure means exposure to mine hazards or hazards at mining operations of more than 5 consecutive work days. And that is what it is. That's how it's defined under Part 46. As we see in Part 48, the question is regularly exposed, and it means frequent exposure or extended exposure. So they're phrased a bit differently because the definitions and how the standards are written are a bit different, but both of them are similar in what they require for frequent and extended. And extended is going to be more than 5 consecutive work days exposed to mining hazards. So, the question with extended comes down to very often, is there going to be extended exposure at your site? Or is it going to be for the contractor? Does that exposure extend to other facilities? And I will tell you that MSHA typically will take in the exposure that happens at other facilities when they are determining whether or not a contractor is a minor or a contract employee is a minor. So even though they might not work at your mine site for 5 days, they often can take into consideration if they're down the street or 100 miles away at another mine on those other days. Frequent is a definition that leaves a lot to be desired in that it says its exposure is defined as a pattern of exposure to hazards at mine occurring intermittently or repeatedly over time. And in Part 48, it's similar. Frequent exposure is exposure to hazards at a mine on a frequent rather than consecutive basis. So it's always helpful when, you know, a regulatory body uses the same word they're trying to define in the definition. You know, you always got to love that. But when we talk about frequent exposure, it's going to be how often is the company coming on site, or how often is that individual employee going to be on site, because this is typically an analysis that's done on an employee basis for contractors, not on a company basis. Because when we're arguing a training citation issued to a contractor, we're arguing about that specific employee. So that's something to keep in mind. The company may be subject to the Mine Act, while that employee may not have been required to have the training under Part 46 or Part 48. But frequent in terms of what we see, you really have to look at the case law for this. We're going to talk about a case here in a bit where a company had contract employees on site, and they were an independent contractor, and those employees were on site twice over a roughly 6-month period, once for 3 days and once for 6 days. And the judge found that that was not frequent or extended periods. I think that is a pretty industry-friendly interpretation. There's other judges who have found that if you are coming on site on a monthly or even a bi-monthly basis, that could be considered frequent exposure. And again, you know, frequent or extended is what we're looking at, so it can be one or the other, specifically when we're looking at Part 48. So when we're worried about a contractor coming on site and having trained for their miners, we want to look at how long are they going to be on site. Is this a one-off kind of job? Are they going to come, install something for 2 days, and then we might never see them again? Or is it going to be a service provider? I know a lot of companies use third-party mechanics, and that is a situation where those individuals are most likely going to fall into the frequent and extended exposure, so they're going to have to require training or comprehensive training. So it can be a gotcha type of phrase. I think that frequently, if you're going to argue it, you need to be very sure about the number of times that individual has been on site and will be on site. So obviously, if you're going to be doing a job that you don't anticipate seeing them again, I'd say that that is infrequent. You know, even if they might have to come back 6 months later, yeah, you didn't plan on it. I would say a good rule of thumb if you're trying to determine frequency is, do you have established a certain amount of time that you know you'll see that individual again? And then if that is the case, you need to think about, well, how often is that? And how long are they going to be here when that visits take place? So some other things to think about when we're talking about jurisdiction is not just over a specific facility or a specific procedure or process on our facility, but also the people that are working on it, and especially in terms of contractors. So after looking at all those definitions, we'll talk about how those definitions have been implemented in some recent cases. Now, this one is about a year old at this point, but it's nonetheless a pretty startling departure from what was the interpretation that MSHA was enforcing. And this case was called Maxxim Rebuild, and it was issued by the Sixth Circuit Court of Appeals, which meant it superseded the decision of the Federal Mine Safety and Health Review Commission on the matter. There is a question as to how this would hold up if the same case was contested in a different federal circuit. And, it could be interpreted differently, but, with so few cases making it to that level for the mining industry and interpretation, I think that we could probably count on other federal circuits at least giving this case a great deal of consideration and persuasive authority when making their determination. But with that said, we'll discuss another case after this that seems to buck a normal trend that we would think in the description of milling. But nonetheless, in Maxxim Rebuild, the question was whether an off-site fabrication repair facility that was used to make and repair mining equipment for the coal industry was under MSHA jurisdiction. And to give a little bit of additional background, the facility used to be on a coal mine. And at that point in time, they were inspected by MSHA. And the company, Maxxim Rebuild, is actually a subsidiary of a coal mining company. And the building they were in was off mine site at this point in time because the mine had been abandoned. There was actually coal mining offices for the parent company in the top portion of this building, but on the bottom floor, the bays, were operated by Maxxim Rebuild, where the majority of their work, great majority, was fixing and repairing coal mining equipment. And Maxxim has a number of facilities, and they were divided between those under MSHA jurisdiction and those under OSHA jurisdiction. And they had previous operations where the mine was abandoned and OSHA assumed jurisdiction. MSHA no longer went on site. Well, in this case, some inspectors showed up and issued citation not to the equipment in the mining equipment in the Maxxim shop, but on the Maxxim shop itself. So at that point, Maxxim contested it, saying that you don't have jurisdiction because we are no longer part of a mine. And previously, there was some important elements of the Mine Act on this question, meaning what extent does MSHA have control or jurisdiction over off-site facilities. Some review commission decisions from the Federal Mine Safety and Health Review Commission, specifically one in a Jim Walter Resources case, which said MSHA has jurisdiction over off-site facilities. In the Jim Walter case, it was a warehouse that was not on mine property. So the company contested, the ALJ found in MSHA's favor, the commission found in MSHA's favor based on these previous cases, and the Sixth Circuit held that the facility was not under MSHA's jurisdiction, that OSHA had jurisdiction over it. And that was because it did not meet the definition of coal or other mine. And specifically because MSHA jurisdiction, according to the Sixth Circuit, only extends to such facilities and equipment if they are in or adjacent to, and as they said, in essence, part of a working mine. So this was a very big decision, as you can most likely see why. The court found that MSHA's or the Secretary of Labor's position was not reasonable, that they had jurisdiction over anywhere that mining equipment went. The court further said that once an agency tries to extend its jurisdiction to off-site shops, there's really no limit to where they can take that jurisdiction. So this was a very big decision. It limits it to locations and equipment that are part of or adjacent to the extraction and milling sites. So if you have off-site facilities that are not part of a mine, this is an area where we've been pushing back a bit more with MSHA, and this decision has been persuasive in the agency relinquishing control over some of those off-site shops. Again, I suggest that you be proactive if you want to contest jurisdiction such as this, so you have an off-site facility that MSHA maybe in the past has gone to. I would be proactive and without an inspection go tell MSHA, hey, we don't think you have a right to be in here anymore, respectfully. and this is why, and get talking with the districts on that. So this was a very big case, though. It has had some ripple effects, and I assume it will continue to do so. Now, in a situation that many of us probably don't or can't contemplate that well, in this Cranesville aggregate case, which was issued by the Second Circuit just a few months ago in December, the company was actually arguing that no, OSHA doesn't have jurisdiction over us, MSHA does. And as many of you know, one of the biggest differences between OSHA and MSHA, and one of the reasons that many companies seek to be out of MSHA jurisdiction, is the mandatory 2s and 4s, so to speak. So 2 inspections a year for a surface operation, 4 for underground. In this case, what had happened was hazard complaints had been called into the Cranesville, or OSHA, about the bag plant at Cranesville Aggregates, one of their mines. And OSHA went out, because they had got these hazard complaints, to a bag plant and issued, hundreds of thousands of dollars in penalty. So they went and they contested these citations issued by OSHA, saying, no, we're subject to MSHA's jurisdiction. You have to vacate all these citations. So that's why we see it going the other direction. Typically, we wouldn't be seeing, or typically I don't deal with companies trying to get into MSHA's jurisdiction. But what happened was the ALJ said, yeah, this is clearly milling what was taking place. They were talking about a specific processing area on a plant where they were drying and bagging material for cement to be part of a cement mixture. And the material was extracted. It was then processed and put in stockpiles. Some of it was sold directly from those stockpiles. Other material went into this bag house where it was mixed with other ingredients and dried and put into bags. So the ALJ said, no, this is clearly milling, they're drying. The Occupational Safety and Health Review Commission, which is the equivalent to the Federal Mine Safety and Health Review Commission, they had 2 commissioners at the time, and they were split and in their decision whether or not it was under OSHA or MSHA, and that made the judge's decision final. And at that point, it went up to the Second Circuit. And the Second Circuit essentially said that this is the transfer point between the mining and the milling and manufacturing process, and that the Secretary of Labor and OSHA, they were reasonable in their conclusion that the drying after the product had been finally stockpiled and some sold, that drying and mixing process was part of OSHA or under OSHA's jurisdiction and not MSHA's. Now, I say this is surprising because I've seen MSHA argue the exact opposite in previous cases, where they say, no, that is still part of the milling. So this is an interesting case because one part of OSHA is arguing, or the Department of Labor is arguing one way, and we've heard the same argument the other way from MSHA. So, it was a big decision because it distinguished that something that is clearly milling from the definition, drying material, was part of the milling, or not part of the milling process, but the manufacturing process, because it was happening after material was stockpiled. And both companies, had put experts on that said it was milling or that it wasn't, but it was nonetheless ruled in OSHA's favor that they had the jurisdiction in this situation. And like I said, it calls into question what we've been established since the late 70s as understanding that milling is always under MSHA. It also split jurisdiction in a single building, a single structure between the 2 agencies. So the milling process, the bagging processes, those are under OSHA. There was also a repair bay or maintenance shop in the building that had remained under MSHA. So a very interesting decision and a very interesting stance by OSHA. I think obviously the fact that they had issued over $450,000 in penalties probably influenced their position. which industry would obviously argue is a litigation position, not an official stance of the Secretary of Labor. So another one that we talked about earlier briefly is H. Biddle & Son, and in this one they operated a stockyard, and they had screens on that, and they didn't extract, but they purchased material from mines in the area. They then separated and resold, and they separated it by size and resold in different products, and MSHA found that that was enough to make them a mine under the milling processes, because they were sizing and separating based on size to sell, even though there was no extraction taking place. The company also argued that there was other facilities in the area that did the same thing, and MSHA just kind of said, well, that's not really persuasive to us. We just haven't made it there yet. So these jurisdiction battles, oftentimes you see that where there's similar operations that are not being treated the same. But nonetheless, that is not a completely persuasive argument for the agency's position. But in this case, just separating material by size was enough to get them under MSHA's thumb. We talked about before the frequent or extended. Thompson Electric talks about this. This was the case where mine had hired an electrical contractor to hook up electricity to a dredge. They had been there at one point in time doing work, and then several months later came back and worked for an additional amount of time until MSHA kicked them off for not having training. The company contested that they were under MSHA's jurisdiction because they were not involved in the mining process, and they did challenge whether or not their employees were required to have mine training. They kind of split the baby there in that the judge found they were involved in the mining process. The company was required to have a training plan and was able to receive citations, but the judge found that none of the employees were on site for frequent or extended periods of time, and that they were not required to have comprehensive training as such. So that is another interesting one. And a final one on training, a final case on training was back in 2016. The decision came out, and it was an ALJ decision, so it's not binding, but it is persuasive for other cases that come out, as were the H. Biddle and the Thompson Electric cases. Those were ALJ cases. But this had two issues in it, and it was whether or not environmental cleanup workers were miners under the Act, so similar to that question about frequent or extended period, and whether the production operator was liable for a contract electrician who did not have all their new miner training. And in finding, the judge held that the environmental cleanup workers were not miners because they were not on site for frequent or extended periods of time, even though the company had been out twice, the individuals had been not, and they were not involved in any milling, crushing, or maintenance. So finding that cleaning up a spill was not a mining, milling, or maintenance. The more important element was, excuse me, whether or not the mine was liable for the contractor training. We see that in this case, the mine argued that under my MSHA policy, MSHA can, under extraordinary circumstances, issue a mine a citation for a contractor failing to have training. And the mine argued that that was not satisfied because they had offered for the miner to come to their training under the miner's own training, or the contractor's own training plan. They had performed site-specific. They had audited their contractors and removed from the site contractors who didn't comply with MSHA training requirements, and that was part of their pre-qualification process. So even though the contractor was on site and did not have all the training for one of their personnel, the mine operator had that citation vacated because of the proactive steps they went to do to make sure that their contractors were complying with MSHA regulations. So that's an interesting one. I know I'm trying to clean up for you guys, and we're just about done, so thank you for holding with me. But if you have jurisdiction concerns, you want to challenge it as soon as possible. The longer you sit back and say, oh, well, MSHA didn't issue me any citations, so I'm just going to wait until I get a citation, and they inspect the place 4 times before we make our arguments, that is going to significantly, and I should say adversely, affect our arguments that they should not have jurisdiction because we weren't doing anything at the time. So if you have concerns about jurisdiction over a property, I recommend you explore whether or not you can challenge that or want to challenge that as soon as possible after you become aware that, maybe this isn't under their jurisdiction. So, to do so, you don't have to wait to have a citation. Obviously, you have a citation, then we're eligible for going into expedited proceedings and really putting the pedal to the metal if we want, if it's a real big burden that MSHA is putting upon us. But we can just begin dialogue without enforcement with the field office and district personnel. And I say field office because you can go to your field office. They are going to kick that question up to the district. But just from working with, the bureaucracy that is a government agency, it's typically, even if it's just a quick phone call to your field office, say, hey, we have a question about jurisdiction. Do we talk to you or do we talk to the district? It's typically good just to give that due, we'll call it respect to the field office supervisors. Typically, though, jurisdictional questions are handled by district personnel. I think that jurisdiction is a complicated matter. It's very fact-dependent and very case-dependent. So, I think that it is an important element when you're going through these to notify counsel for the purpose of really doing a full evaluation of your question of jurisdiction, or whether or not maybe you are going to go and challenge something that had no business being challenged, and now we're going to have some bad case law that's going to affect the rest of the industry. So I think that that is an element that at least you want to run that argument by MSHA counsel. It doesn't mean that we have to handle it for you, but I think it's good to have that analysis going into it, and we can provide some assistance on the evaluation portion of it. So with that, thank you to everyone for joining. We still have the blog, so feel free to check that out. We also have 4 more webinars scheduled for this year, the next one being the status of the final rule for metal, non-metal workplace exams. It's scheduled to go into effect on June 2nd, so we're going to have a status update just a few weeks prior to that and see where we're at and in what form it may or may not go into enforcement. So if there's any questions, or if I didn't answer your question sufficiently, please let me know and send a message in the chat, or please feel free to give me a call or shoot me an email. I hope that you guys found this useful, and I will look forward to hearing from you or seeing you at the next presentation. So thank you very much. All right, it looks like we don't have any questions, so thank you again for joining, and we will stop the meeting at this time. Thank you.